Welcome to Case by Case. This is a podcast brought to you by Calum and Luke Zadkovich from ZFZ. How are you, Calum?
I'm very good, Luke. This is episode number 2 of the new season, the two babies season, as it feels. And yeah, we've made it to 2 episodes, which is good.
That's right. I don't know about you, but I've been finding it a bit hard to get back into the swing of finding the time to read the cases and, lock in a time with you to do the recording. We've got to get back into the swing of it. I don't feel like, I'll be honest, that I'm yet in the swing. It doesn't help that I've been traveling a lot. I've just come back from New York and seen a bunch of clients and caught up with colleagues over there. So a lot happening as per usual.
There's a rhythm to finding the cases, looking for the interesting cases that are out, that have been released by the courts, knowing the right time to get the recording done. It's a rhythm, and we're not quite there yet. Still a little bit of friction for this to pick it back up, but we'll get there. We're recording now.
Yeah. So, Calum, did you manage to join the LSLC seminar that we had in our London office recently on the Arbitration Act?
Yes, I was involved. Obviously, that was led by Jonathan Webb, who joined us, probably a little while ago now. It feels recently because 2023 has disappeared in the blink of an eye. But I was working with Jonathan in setting all of this up. And in the end, I had to join remotely. But it was a fantastic event. It was quite humbling in a way to have such an esteemed panel come to speak to us in our office, or come to speak to the LSLC, but to host them in our office. A significant panel of ex-judges, current judges, high-ranking KCs. A really kind of impressive moment for us, if you like. Given the growth of the firm in the last little while, to have those kind of people coming through the door of our London office was awesome.
Yeah, I think you're absolutely right. It's like one of those milestone moments, isn't it, to get to the stage where 7 years down the track, where we've grown to the point where we're hosting events like that, and well known in the industry, and just have that kind of sense of colleagues and part of the community, which is a really nice feeling.
Yeah, it is a nice feeling. And in a similar vein, off to the LMAA lunch tomorrow, and as this episode will obviously come out after the lunch, but that's another thing which is nice to be getting involved in that side of things as well, and being a real part of the London shipping community there. Why
don't we get into the episode for today? This is a good one. I think we're going to enjoy this. It's going into an area of the Arbitration Act that some of our listeners may not have delved into before, but can actually be, practically speaking, quite useful. And that's the case of JOL, JWL as claimants, and JPM as the defendant. It's a decision of Mr. Justice Foxton of the High Court in England and the Commercial Court, neutral citation number 2023 EWHC 2486 COM, and was handed down relatively recently in October 2023. And this matter involved an application under Section 44 of the Arbitration Act of 1996. It was also brought under Section 37(1) of the Senior Courts Act 1981, but it didn't end up ultimately proceeding on that basis. It was all about Section 44. And this is a section of the Arbitration Act that sets out what the court can do in its supervisory capacity over a London arbitration. As many of our listeners will be aware, we're talking about disputes or claims where the parties have agreed to send them off to arbitration. In this case, we're talking about English and London arbitration. It's for the arbitrators to decide on the merits of the substantive dispute between the parties. However, the court retains a supervisory role over the arbitration, and it has certain powers, kind of interim relief and interim powers that it can use to preserve property and to preserve assets as the arbitration process is playing out, because it can sometimes be the case that it takes a while to get to a decision in an arbitration, and a court can move more quickly and can make orders more quickly right at the outset of a dispute to preserve the status quo and preserve things. So that's what we're talking about today, this supervisory role that the English court has over London arbitration.
This is a tool that we use, maybe not regularly, but not infrequently. I think I wouldn't have to go back more than I don't know 6 months since the last time that I used Section 44 application. So it's a really useful tool in any arbitration lawyer's armory, and this is quite an interesting case, I guess, from our perspective, given that it's got this kind of shipping background, but a point of really general application to anyone with an arbitration practice.
Yeah, I think that's right. I'm the same as you. I don't think it's even been that long since my last Section 44 application, or considering making a Section 44 application. And it can be used in different contexts. This is not just this is a case related to shipping, but this is not a principle that's restricted to shipping at all. And indeed, one of the main cases that this decision looks at is not a shipping case at all, and it sets out some of the principles that guides the court in exercising this power. So before we get into the relevant section and looking at the law on this, I think it might be helpful just to set out some of the bare bone facts here, Calum, if you agree.
Yeah, the bareboat facts, if you will.
I like it. What is a bareboat anyway, Calum? It's an in joke for anyone in the industry, but we do have plenty of listeners that aren't from the shipping world that won't know what a bareboat charter is.
This dispute involves a number of back-to-back bareboat charter parties, and the bareboat charter party, typically, if you have a time charter party, which is one of the more common types of charter party that we see, the person who owns the ship will deal with all of the kind of operational stuff involved in running the ship. They'll hire the crew, and they'll have a bunch of operating expenses that they need to pay, and that will all be baked into the rate of hire that the charterer pays for the ship. In a bareboat, all of you're effectively giving the boat bare to the charterer. So the owners are not putting a crew on board. They're not dealing with all these operating expenses. That they're simply giving a ship. So you see a lot of bareboat charters in things like financing arrangements, where it's not really about operating a ship and then hiring it out to somebody else. It's more about having an asset and letting somebody else have complete control of the asset. And I would imagine that the background to this, although it's not really discussed in the judgment, it seems as though the background to this is probably some kind of financing structure, just by the way that the parties are set out.
Yeah, it seems that way, and even the fact that there are multiple bareboat charters on a back-to-back basis within a corporate structure. So I think there's 3 companies perhaps that are involved in a corporate structure with multiple bareboat charters between them, which is all still part of the same group of companies. So there's some structuring, corporate structuring, finance, potentially tax that's related to how these structures are put in place. And it's not so much about the operations of the vessel, as you say. That's for the time charters and the voyage charters further down the chain. This is more about the corporate structure at the top, and there are many reasons for that, which we don't really need to get into the ins and outs of that.
The structure is this: you have the owners of the vessel who sit at the very top of this charter party chain, and they are, I guess, in corporate group A. And then everybody else involved appears to be in corporate group B. So corporate group B starts with the first bareboat charterer. And that bareboat charterer has obligations to the owners, and those obligations are guaranteed by let's call them the guarantor. There's then another bareboat charterer. So the initial bareboat charterer has subchartered on a bareboat basis to a company called GHH. That's an anonymized group name, because we're dealing with an arbitration case here. So I think that's why the parties have all been anonymized. And then there's a further bareboat charter to the sub-charterers. And in the head bareboat charter, so this is effectively the link between corporate group A and corporate group B under this top bareboat charter. There's a provision which says that the owners can terminate the charter party if the guarantor ceases to own a certain percentage of the GHH company, that intermediate bareboat charterer. So a little bit of a tricky structure, but effectively you've got 3 back-to-back bareboat charterers. You've got a guarantor who's guaranteeing the charterer's obligations under the top bareboat charter, and then you've got a requirement for the guarantor to continue owning one of the other parties in the chain in a certain percentage, and that's a requirement of the top charter between owners and head owners and the top chartering entity from the second corporate group.
Yeah, exactly. And the guarantor's shareholding had to remain above 77.4% to be precise. And it was actually common ground that that percentage dropped below the threshold on the 2nd of September 2023 as a result of a reorganization of that group. I think it had to do with financial difficulties. And so it wasn't really in dispute whether a termination event had occurred or not. There are other disputes in this matter, of course, pretty quickly thereafter. So this happened on the 2nd of September. Owners then served a termination notice on the charters on the 5th of September, so only three days later. And a short while after that, on the 20th of September, the owners then commenced arbitration and appointed a very well-known KC as their party-appointed arbitrator. And the charter has appointed their arbitrator, another very well-known KC, on the 28th of September 2023. So arbitration was commenced pretty quickly thereafter. A panel was constituted, and as we've talked about before, it's okay in LMAA arbitration to have 2 arbitrators only on a panel of 3. And they can continue to handle the arbitration until such time as they don't agree, and they appoint an umpire, appoint a third. And so that was the situation before this application was brought to court. And then owners commenced in court under Section 44(3) of the Arbitration Act and sought the courts, sought to exercise the court's power to basically force through the termination, the consequences of the termination, if I can put it like that. And I suppose putting it like that kind of answers what ends up happening here in a way. But owners were contending that they should get back get back the vessels. Once the bareboats are terminated, then charters are obliged to redeliver those vessels to the owners. And the practical problem here is that the bareboat charterers, this group of or set of them, had then contracted out or chartered out on a time basis to other third parties that were not part of the bareboat chartering group. So the vessels were out there being exploited under commercial contract to other parties. And the owners, the ultimate owners, were saying, well, the bareboat charters are in default under the head bareboat charter. We're terminating that. We want our vessels back. So that would be unwinding and causing a whole lot of hurt and pain down the contractual chain.
An interesting feature of this case is that it was bareboat charters. I mean, maybe the case doesn't even arise if it's not bareboat charters, but normally you would have the owner's crew on board, and the owners would then have some ability to pull the plug on the whole thing and say, oh, actually, we're going to tell the crew to do something totally different. Whereas here they don't. Here the crew are all being directed by the bottom bareboat charterer, because they're effectively the person who is responsible for crewing the vessel. So you have the situation where the head owner wants to get their hands back on the ship, but by the nature of the bareboat charter means that they've kind of washed their hands of the operational control of the ship, which leaves you into this interesting position where they're asking the court to basically help them out. And I wonder if now is a good point to look at Section 44 of the Act itself and the precise words that they were trying to fit this under Section 44, subsection 3.
Yeah. Well, the Section 44, it's quite a long section, actually, but we're only focused on one part of it. I'll just read it out. I think that's the easiest way to deal with it. So Section 44 sub 3 states that if the case is one of urgency, the court may, on the application of a party or proposed party to the arbitral proceedings, make such orders as it thinks necessary for the purpose of preserving evidence or assets. So as you can see from the start of this provision, if the case is one of urgency, that's the first threshold to get into this clause. And that's what we're dealing with here. The owners have said, well, we can't wait for this highly esteemed arbitral tribunal to consider the matter. It may take some time for them to deal with it. This is of extreme urgency. We're rushing off to the English court and saying, you must look at this now. You must look at this now. And as we know, that there are gateways to that. There are thresholds to get into court and say to the court, stop what you're doing. This is very urgent and we need to bother you and ask you to look at this matter right now.
And I think it's maybe worth also pausing there to note the first distinction between what might be a kind of quote unquote classic Section 44.3 application and this type of application. Because if you have some asset or evidence somewhere which looks like it might be being squirred away or disposed of, then you can go to the court and you can say, look, this is really urgent. We need these documents and we think they're in the process of shredding them, or we need to inspect this this oil and they're in the process of flushing it all out. And the court can then say, yes, actually, for the benefit of the arbitration that you're engaged in, we're going to step in and make sure that evidence or that asset is retained and preserved. Here is there's a slight difference in what's being asked of the court, because what they're doing here is they're saying, we have terminated this charter party. We need our ship back. We want the court to step in and give us our ship back. And that's basically what the arbitration is supposed to resolve. That's the dispute that's been referred to arbitration. So they're not looking for some evidence that preserves the party's ability to argue that arbitration fairly. They're seeking the thing that would come out of the end of the arbitration.
Well, exactly. And that's we're kind of dealing with 2 points there, but that's the crux of this case. One is, and they interplay with each other. One is urgency, whether this matter is sufficiently urgent that the court should step in advance of the tribunal making its decision. And then it's this second one, as you say, where is the court being asked to basically preempt what the panel, the arbitral tribunal, is being asked to rule on? Is the court making the substantive decision on what the relief will be sought in the arbitration? And if it is, and Lord Justice Mayles has dealt with this issue a couple of times in two prior cases, the court should be very reluctant, or not very reluctant is not the right word, but should exercise caution, or it should be a factor in assessing urgency and whether at all Section 44.3 should be rule in favour of the moving party if the court's being asked to actually dispose of the case in some way, or rule on what the substantive relief that will be sought in the arbitration is. Yeah,
exactly. And as you say, there's an interplay between those two issues. And I think that actually there's a very nice paragraph in this judgment, paragraph 27, where that interplay really comes to light. And Mr. Justice Foxton effectively says, well, the argument that's being made for urgency is that there is a right which is enforceable now, and if it's not enforced now, then the innocent party will forever lose its ability to have enforced the right immediately. There's a right to something immediately, and if it's not enforced immediately, then it can never be enforced immediately again. And that was the argument presented by the applicant. And Mr. Justice Foxon kind of dismisses that argument and says, well, yes, but that's true of every single contractual obligation, which has to be performed by a particular date. So that's not enough to get you into this urgency. You need to show us more than simply saying this obligation had to be performed on a certain date. In this case, the redelivery of the ship had to be performed on a certain date. You have to go beyond that and say, why is it so important that this obligation was performed on this specific date?
And that's why these decisions end up a case-by-case, pardon the bad pun, basis, because it will turn on the facts of any individual case. Here, the court was not convinced that there would be some damage to the vessel or something would happen to the vessel in the interim between now and when the panel will be able to rule on the matter. I think the court here said that it was likely to be about 6 to 8 weeks for the tribunal to be able to rule on this issue if done on an expedited basis. And during that period of time, factually speaking, it did not seem like there was any additional reason to bring forward that consideration. We could come up with hypothetical scenarios where that might be different, where there could be real reasons why it needs to be decided now, and that there might be prejudice suffered and that property may go missing, and there are examples given in this decision, of course. The other point I wanted to touch on, though, is it's a language point on Section 44.3, Calum, and that's the word purpose, which I wanted to emphasise because I think it's one of those points that may not leap off the page when you first read the provision, but the authorities get into this, and the Section 44.3 power is broader than it may seem at first glance, because it's not necessary that the order is one for the preservation of evidence or assets. Okay, it could be, but it doesn't have to be that. It needs to be for it's enough, if you like, or sufficient for the order to be for the purpose of preserving evidence or assets. And so in that way, a contractual right, such as the right to purchase shares, as was dealt with in another case, could be an asset for this purpose. And that's important. It doesn't leap off the page, I don't think, that it kind of extends that far, but it certainly does. And it's why here it wasn't a complete answer to this application to say, well, the owners are seeking to enforce a contractual right here. That's not an asset. Well, it is for the purpose of preserving evidence or assets. So it kind of fell within that realm, but it still had to go through these other elements of the test.
There are 2 points in that. One is that it's broad enough to be for the purpose of preserving evidence, and the second is that an asset would include a contractual right, because that again doesn't leap off the page. When you think about what is an asset, what is evidence, which is what this clause goes to, you don't immediately leap to contractual right fitting the bill. So it is broader than perhaps it seems. Section 44.3, you can, in theory or in principle at least, you can go to the court and ask for an order, the purpose of which is to preserve your contractual right. And there's case law that confirms this position.
It is, and that's where Lord Justice Mayles, when he goes into this analysis, he exercises some caution there, and he says, well, when you're looking at this bundle of assets which are contractual rights, and you're asking the court in its supervisory function to do something with respect to those contractual rights, often that's when the court will be, delving into this realm of actually deciding the substantive issues that are between the parties. And so it's in that area where, yes, it's absolutely right to say that a contractual right can be an asset in this context under this provision, and there's authority for that. But it's also that category of cases where it gets closer to asking for an injunction that might tread on what the arbitral panel's ultimately having to do.
Yeah, and that's a fundamental tension between what the power the court has under Section 44, subsection 3, and the general principle, which is that if parties have agreed to arbitrate, if parties have agreed that their disputes are going to be handled by someone other than the court, then the court shouldn't step in and resolve those disputes in place of the arbitral panel.
Cutting to the chase on this one, ultimately the court found that there wasn't sufficient urgency to grant the relief for owners. Did you want to say anything about why more than what we've already gone into, Calum?
What I was really impressed with in this decision, and I suppose I shouldn't be, because it is perhaps something that you need to do, as you say, it's case by case. But the court really looked at the possible prejudice, and they said, well, hang on a minute, there are a number of vessels that were related to this. I tried to kind of simplify it in the initial description down to one charge party chain, but there were a number of vessels with the same structure. And they said, well, you've already been paid your October hire, so there's no immediate prejudice in you missing out on hire payments. So there's no risk there. For one of the other vessels, they said the ship's actually going into dry dock in November. So at that point, it's not really going to be in use anyway. So the court was quite methodical in saying, okay, well, we think that the delay that you're going to suffer is between 6 and 8 weeks. They actually gave what seemed to be a little bit of a nudge to the tribunal, saying that there. I don't know if you clocked that one, Luke, but I thought it was quite funny. See if I can.
I read that as well. It was almost like a bit of a well, here you go. Can you do it in that time frame? If not, ask us to deal with it. Because joking aside, tribunals can refer points off to the court. There's actually a specific provision that allows for that.
That was an interesting part of this judgment. I'm kind of getting slightly away from the point I was initially talking about, but I did find it quite funny. It's in paragraph 30, where they said the two party appointed arbitrators are commercial barristers and arbitrators of great experience, expertise and distinction, and the court has particular confidence in their ability to conduct the hearing efficiently and to proceed speedily to an award. I thought that was a very kind of polite piece of motivation for the arbitrators to move quickly to an award there. Going back to the point, the court didn't just say, well, there's no real urgency here. The court actually said, okay, but what's the alternative? The alternative is you go through this arbitration process. That's going to take you between 6 and 8 weeks. In the next 6 to 8 weeks, what's the risk that you face? And they said, you've already been paid higher, so you don't have a kind of financial risk that you're not going to get the payments that you would otherwise be entitled to if the charters are still on hire. And they said, well, and then after that, the ship is going into dry dock. And if the ship's going into dry dock, you're unlikely to face a substantial risk of anything bad happening to the ship as well. So on those grounds that were really rooted in facts and what actually is happening on the ground, the court said there's no urgency for you to come to us now and say that 6 weeks is too long, because in practical terms, in those 6 weeks, you're not likely at all to suffer any loss. And I thought that was a sensible approach and just a very well-reasoned approach.
If the court stepped in now and granted the relief sought by owners, and ultimately the arbitrators went a different way on it, it would be very difficult to reinstate those charters down the chain and put the parties in a position where they are at the moment if the vessels were redelivered and all the rest of it. It just wouldn't be possible at all. So yeah, I think that was a big factor weighing on in the court's consideration here.
Yeah, and there was one last point, I think probably around the point that we should be wrapping this one up, but there's one last point that I thought was very interesting as well, which is, as you mentioned, the possibility for the tribunal to give permission to a party to bring a Section 44 application if it's something which is outside what the tribunal can do. And the court said in their kind of conclusion, or in their final remarks, they said it may be the case that the tribunal looks at this and feels like they're not in a position to reach a final award in the next 6 to 8 weeks. And if that is the case, then they noted that under the LMAA rules, the arbitrators would not have the power to offer any interim relief to the owners. And they said the tribunal then may wish to give owners permission to bring an application under Section 44(5), which is another section of the Arbitration Act. And the court then went on. I found this really interesting. They said, Mr. Justice Foxton said, I would not regard the fact that the LMAA tribunal does not itself have the power to grant interim injunctive relief as precluding it, to the extent it thought appropriate, from expressing its views on the merits of such an application when ruling on an application by one party for permission to apply to the court for Section 44 relief. So they almost said that it's not a backdoor for a tribunal to give this relief, but you can almost see yourself now going to a tribunal and saying, hello, tribunal, we want to make a Section 44 application. We would like your permission to do so, and we would also like you to indicate for the court the direction that you think you would go if you were asked about offering this relief. It seems like the court is leaving the door ajar for a bit of direction from the tribunal, so that the court can make sure that it has this balance between allowing the dispute to be conducted by the tribunals who are appointed by the parties, and bearing in mind arbitration is always this consensual process, and the court really wants to give effect to that, but also using this remedy and using the supervisory jurisdiction of the court in order to at least pay heed to what the arbitrators think about the potential interim relief.
Yeah, I think it's a really good point, Calum. You've really narrowed in on something interesting there. I kind of had a similar thought on this, maybe not quite about getting the guidance from the tribunal, but I think it's a good pickup you've made there. I had almost like a practitioner's tip here, or we're constantly learning, and I almost took the court to be saying here, well, you should have really approached the tribunal first and see, one, where they stood on ruling on this as to how long it would take, two, whether they were minded to, and whether they thought they had the power to grant the kind of relief sought on a interim quick basis, and then whether they're inclined to make that order themselves, or whether this is one better put to a court. And it almost felt a little bit like I'm not going to say never on granting this relief by the court, but really go to the tribunal first and then come back to us. And the practitioner guide here is I actually think that if you're looking to do a Section 44, the court wants to see you engage with the tribunal to some extent to see what they are thinking about it, how they are suggesting this gets resolved, rather than just rushing off to court without having asked the tribunal anything about it. Now, there will be cases where you need to act before a tribunal has even been constituted, or only one party has appointed its arbitrator, or what have you. So every case is different, and I need to stress that. But in this case, particularly where two very senior KCs, leading KCs in the field, are appointed on both sides in pretty short order, within a couple of weeks of the issue arising, it would not have been a difficult proposition for the parties or owners to ask the tribunal first what they think of this before going off to court. And my takeaway was that was pretty much what Mr. Justice Foxton ultimately found here.
Maybe that's particularly the case in a forum like the LMAA, or under rules like the LMAA rules, where the interim relief is not something that the tribunal can offer. That the court still wants you to go and say to them anyway, well, can we have your permission to go to the court?
Well, look, I've really enjoyed this one. It's one of those ones that I don't think a lot of our listeners will come across very often, but it's quite a useful issue to think through, and just understanding that you have an arbitral tribunal and you have a court that's supervising that arbitration, and it'll be the seat of the arbitration that determines what court is a supervisory court. So it's an important understanding, I think, to have anyone that's in this field or agrees to arbitration agreements in their commercial contracts or is advising on them. So if you've gotten this far, thank you. We hope you've enjoyed the pod today. I know I did, Calum. Good to catch up with you as always.
Yeah, that was a good one. I found it a really interesting case, a really interesting look at Section 43. And it was a nice one to kick around as well. I took something, well, you seem to take in a couple of things different to me. So it was an interesting one to chat through.
Until next time, take care, everyone.